I want to get your thoughts on this concept of ambiguity because you raised it earlier when you were talking about your judicial philosophy. Um, and I'm really interested in your thoughts on this. Don't you think the concept of ambiguity is ambiguous? I mean, what does it mean?
Thank you, Senator. I think the binding case law talks of ambiguity in the sense of if more than one reasonable conclusion could be reached on the question that is pending before the body.
Well, this is what I'm getting at, Judge. Does it have to be 51% ambiguous or really ambiguous, like 80%? What if you look at it and you go, I think I know what they mean, so I guess I'd give it a 40% ambiguous. How much should it, how do judges approach that? How do you approach it?
Thank you. So I'm not all that great at math, as you may have understood from the things that I've studied. So I don't approach it with any mathematical precision, and I don't believe that the case law of the Supreme Court or the courts of appeals require me to approach it with any type of mathematical certainty. Of course, as you know, I don't just decide issues I want to decide. Parties bring actual concrete disputes before me. They write briefs, they cite to cases, and they make certain arguments. And so I get very focused on the case law, the arguments the parties make, and apply all of that to the facts of the case before me. And through that process, make a determination in a particular case whether a statute is ambiguous.
What kind of guidance has the United States Supreme Court given our lower courts on the definition of ambiguous?
Senators, I sit here, I'm not sure. I can't think of any particular precedent as I sit here, but in the more than 2,000 opinions I've written, I'm sure that I've cited whatever the binding Supreme Court precedent is on that question, as well as the binding precedent of the Third Circuit. And if confirmed, I would continue to faithfully and diligently apply binding precedent.
Okay.